Hi, good evening, everybody, and welcome to another episode of Tuesdays with Mitch. I'm your host and fellow paralegal here at Proner & Proner, Emmeline. We usually are live, but this episode is pre-recorded. Why, Mitchell?
Well, it's interesting. So right now, I am actually in Spain. There's a convention for attorneys that represent victims of accidents, no insurance carriers and nobody representing big corporations or pharmaceutical companies or municipalities. It's just attorneys that represent victims. And what we're looking at is big data, where some data scientists, one from Cornell, one from Washington, and different data scientists from around the country have gotten together, and we're looking at focus groups where they'll take 2,000 people from a community where a case is going to be tried, and they'll present the case to 2,000 people online by putting together all the evidence and exhibits and what the doctor's reports are and what the other side is. And then after they present it online, the case is actually tried before a real jury in a real court with a real judge. And we look at the data that is accumulated beforehand and what the actual verdict that comes back is, to see if changing the order of the presentation of the evidence and how the evidence is presented, the amount of money that's asked of a jury can affect the awards. And it's really exciting stuff. And we've got about 80 attorneys from across the United States that all have tremendous track records of winning really big verdicts, hundreds of millions of dollars. And we're getting together with a data scientist to look at how we can make our craft a little bit better as trial lawyers. So it's an interesting convention, and I'm glad to participate. And it's this week in Madrid, Spain, and that's where I am. But I pre-recorded this program with you, Emmeline, for consistency, so that we can have a program that's new and fresh every Tuesday for the audience that's watching us live.
You see, guys, just for you, and honestly, that sounds super cool. Learning never stops. Mitchell Proner, a personal injury attorney of over 30 years, and still continues to find ways to learn new tricks and put them up his sleeve. So today we have a really cool and interesting topic for you guys today. We're going to be speaking about $1 million case. This case is about a worker who slipped and fell on ice from a cement truck. Now, Mitchell, how exactly did this accident happen?
Okay, so let me just address something you said. First of all, no tricks up my sleeve. There's nothing tricky about what we do. I think the insurance carriers, they're the ones that engage in tricks, and I'm going to be doing a little bit more on that topic in a later program. But here, all we're doing is we're looking at the real evidence. Nothing is doctored. Nothing is there's no Photoshop changing what things look like. It's actually using the real evidence and just trying to make intelligent decisions on how to present it. And how we present evidence is, a lot of it's nothing different than ancient times when Cicero and the Greeks and the Romans studied rhetoric and how to structure an argument so that it presents itself in a coherent and persuasive manner. Now we're just using big data to do it a little bit better, but there's nothing tricky about it. So getting onto the topic today about the case. So the case was actually a case where a worker was part of a large construction project here in the city of New York, where a contractor was hired by Con Edison as part of a large project. They were doing the streets on the Upper West Side, and whenever you dig up the streets, of course, there's a lot of infrastructure under there, and part of that infrastructure is Con Edison. Now, Con Edison didn't have Con Edison workers. They actually hired a contractor, and my client was a worker for one of these contractors. And what happened was Con Ed had these trucks, and in the back of the trucks were conduits, these large plastic tubes that Con Ed's equipment was going to go in. And these tubes were wrapped in plastic. And my client was hired by this contractor. He shows up at work at 7 o'clock in the morning to unload these tubes from the back of a truck. And as he's unloading the tubes from the back of the truck, what he doesn't know is underneath the plastic, because the trucks were kept out overnight, was ice. And when you put plastic on top of ice, it's a very slippery substance. So as he's taking out these conduit tubes from the back of the truck, he slips on the plastic over the ice and he falls out of the back and he gets seriously injured. And he wasn't able to return to work. So first of all, Con Edison said it's his fault. They said he was the one unloading and he should have been aware of the surface that he was working on. And he was the one that unwrapped the tubes and put the plastic on top of the back of the truck. And they said his only recovery could be from workers' compensation. And in fact, workers' compensation was paying his medical bills and his 2/3 of his loss of earnings. But we brought a third-party action, which wasn't part of the insurance company from his employer, against Con Edison, saying that they left the trucks out overnight and it was their fault for having a hidden dangerous condition. And there was actually motion practice where Con Ed moved for summary judgment, trying to get the case thrown out as a matter of law. And we opposed that motion, and we were successful in arguing the case on the law, creating case law. And as a result, right before the case was about to go to trial, they came to us with a settlement offer and the case settled.
Now, during the beginning of this case, when you really start looking at all the aspects, what was some key evidence that you started to find in order to make settlement successful?
Well, first off, we had photos of the truck, and it actually showed our client standing up outside the truck. Initially, he didn't realize his injuries were going to be as painful and as debilitating as they eventually proved to be. A lot of times, right after somebody falls or hits the ground, they might not feel as bad as they're going to feel. And then it's only at night or the next day they really start to feel the effects of their injuries. And then they might go for therapy and try to get treatment, and unfortunately they can't go back to their usual level of activity that they enjoyed before the accident. And that was the case with this client. So the first thing was the photos of the accident scene. The second thing was the weather records and the client's description of the story. And from there, we built the case. We found out who was doing the work, what the project was, and we built the case.
And I believe this client had significant injuries as well, right? I believe he had a broken back and a broken wrist, which also goes hand in hand with a $1 million case, right, Rachel?
Well, he did have injuries to his forearm and his back. His back wasn't broken, but he had disc pathology, which is typical. So if you think about your spinal column, there are hard bones, which are our vertebrae, and in between them are cartilage-covered gel, which are your discs, and they provide the shock absorption for the bones. And this can get damaged in numerous ways. If you think about a disc like a jelly donut, if the disc gets compressed and makes like a bubble, that's typically referred to as a bulging disc. If the disc gets compressed and the jelly squirts out, that's typically referred to as a herniated disc. Sometimes with aging, the disc will dry out, and that's called a desiccated disc. And that's typically why older people start to get shorter, because as the discs dry out, they lose volume and the vertebrae get closer together, and you lose flexibility. Now, this individual, he was working pretty well, but the damage to his discs ultimately required extensive treatment. And because he couldn't get back to work in the construction field, he had lost earnings, and he had ongoing medical bills, and we used that to prove that he had future needs and future lost earnings. Even though he was in his 50s at the time of the incident, he wasn't able to return to the construction industry, and that's what we used to achieve the settlement that was substantial.
I do want to take some time really quickly to remind everybody to follow us on all of our social media. You can find us easily on Facebook and Instagram, Proner and Proner. Also, don't forget to follow our Facebook so you never get left behind whenever we do one of these lives. And also feel free to subscribe to our YouTube because it is free. Now, Mitchell, it would be nice if all cases were smooth sailing and there were no challenges. what were some challenges that you faced with this case specifically?
Well, first of all, no case appears to be smooth sailing if it's a case of tremendous value. That doesn't mean that we don't know what we're doing. After doing this for 30 years, I think I've got substantial experience in the field, and I've lectured across the country on this field of law because I have a reputation for knowing what I'm doing. That being said, every substantial case is going to be defended vigorously by insurance carriers. Because before an insurance, a lot of times there are myths out there. People say, oh, my neighbor, nothing happened to them. They weren't even hurt and they got $2 million. It's nonsense. If a lawyer works for insurance carriers or a lawyer works for accident victims, lawyers on both sides are going to say insurance companies don't just hand over money. And if somebody works for an insurance carrier, they know before they can write a check, they have to justify every cent that they're spending on a claim. Because insurance carriers are a big business. They make their money by collecting as much as possible in premiums and paying out as little as possible in claims. So before they write a check for a lot of money, one thing is certain: they're going to look over every aspect of the claim. They're going to make sure, is there any way possible that they could settle the case for less or go to trial and increase the odds that they're going to end up paying less than they would with a settlement? They are going to look at a case from every possible angle to pay less. And it's not going to be, oh, let's quickly pay some money for somebody that got injured and maybe it wasn't that bad an injury, but let's give away millions of dollars. That's just, it doesn't happen in the real world. So what they'll typically do is, first off, they're going to see if they can settle a case cheap. Secondly, they're going to see if they can prove that the victim was at fault for their own injuries. Third of all, they're going to try and prove that the injuries are being exaggerated or there was a good recovery, and they're going to try and do everything possible to minimize the claim. And this case was no different. In this case, they tried to contest how the accident occurred. They tried to contest the extent of the injuries. They sent video investigators following my client, taking videos. They did, in fact, get a videotape of my client changing a tire. And it's kind of persuasive when somebody's down and they're working a jack and moving a tire. It certainly looks like they could go back to work, even in the construction industry. But the reality is, there's a big difference between going to work for a half hour that it might take to change a tire and working day in and day out for 8 or 9 hours a day. And typically, somebody might be able to work for half an hour and then they could be sore for the next 2 days. And that doesn't mean they could go back to the vigorous activities that are required in a job like construction or demolition.
Now, going off of what you were saying with the insurance carriers and how it is a business, they try to pay as little money as possible to begin with. Did you get an initial offer from the insurance carrier for this case? What was it?
No, there was no offer. There was no offer on this case. $0 were offered up until a week before trial. And then they came back and they paid the number I was asking. And that was it. There was no negotiation. I wasn't negotiating because I said, that's our demand, that's it. We're not taking less, we're prepared to go to trial, because they waited until the last minute. And they didn't make any offers beforehand. One of the reasons why they didn't make any offers beforehand was there was an insurance dispute. You see, Con Ed, when they engaged the contractor, they had an insurance policy on their behalf that the contractor, in order to do business with Con Ed, had to take out. That's called an indemnity agreement. And the indemnity agreement said, if Con Ed gets sued because of any work we do, our insurance will cover Con Ed. Well, Con Ed said, we don't have to pay. we've got this indemnity agreement and insurance. The insurance carrier on the indemnity agreement disclaimed, saying, we're not covering this loss. This is outside the contract. This wasn't our work. This was Con Ed's work. So because they couldn't agree who was going to pay, they couldn't make an offer. At the end, Con Ed knew that we were going to trial, and I had won the motions for summary judgment that they had brought, and the court said we were going to go to trial. And at that point, they said, all right, we'll pay, and then we'll work out the indemnity agreement afterwards.
In the beginning, while you were telling us a little bit more about this case and how it even happened, you did state that he was working. So he did have a workers' compensation case as well, correct?
That's correct.
So what costs were covered under workers' comp?
Okay, so the way it works is, in order to prove you're entitled to workers' compensation benefits, what you need to prove is that you were injured at work, that you reported that injury at work within 30 days, and that you're incapacitated from returning to work for at least a week. So you just have to prove you're working, you're injured, and the injuries prevent you from being able to return to work for at least a week, and you reported it to your employer within 30 days. That's what's required for a workers' comp case. Then you have to fill out a form called a C3, filing the claim with the workers' comp board. You have to have a doctor that documents your injuries, called a C4, where he will say, in fact, that you were injured and that you're under a disability. And of course, your employer has to have workers' comp insurance. But if your employer doesn't have workers' comp insurance, they look for other parties that might be on the job site that had coverage that you might be able to avail yourself for. Or if not, there's a state insurance fund that covers uninsured incidents at work. That workers' comp will pay 2/3 of your lost wages. That's your gross wages without any deduction for taxes, and all your medical bills that are related to the injury you sustained at work. You can bring a third-party action in certain events if you can prove somebody other than your coworker or your employer were responsible for your injuries, or if it's a protected activity like construction or demolition, the GC or the owner of the property might be responsible, depending on where it occurred. But typically, with a third-party claim, which is a claim against somebody that's not your employer, you need to show fault. If you can demonstrate the fault, you can be entitled to not just your lost wages and your medical bills, but you can get future damages for any lost wages you might have in the future, any medical bills you might have in the future, and you can additionally get money for pain and suffering, up to the present and in the future. So a third-party action can often become $1 million or a multi-million-dollar case, depending on the injury sustained and the culpable conduct or the fault that you can prove.
Now, one of our main goals here at Tuesdays with Mitch, when we do these streams, pre-recorded or live, one of our main goals is to get you, the viewer or listener, to kind of understand the world of personal injury a little bit better. So a lot of the times when people have accidents, it's typically or most likely their first major accident in their lives. What's some advice that you would give, Mitchell, to someone who has been injured at work before and has never had a serious accident?
Well, first thing to keep in mind is, more important than any money you're going to get from a claim is your health. And you should get medical attention if you think you've suffered an injury. Like the case that we're talking about today, you might not realize the extent of your injuries initially, and they might be more serious than you initially believe they are. You should get the health care that you need. Don't worry about the bills. An experienced attorney can help get the bills paid for if you were injured at work. The first thing to do is get medical care. When you get to the hospital, don't think, oh, I'll be better off if I say it happened at home or something like that. No. Be honest. If you got hurt at work, say you got hurt at work. Describe all the injuries that you've sustained. This is important because more important than any money you might get, you can get attention for those injuries. And there's an expression, an ounce of prevention is better than a pound of cure. Well, if you have a condition that requires immediate attention, that might be the difference between making a full recovery and suffering for the rest of your life. So the first thing is get the care that you need. The second thing is you should get in touch with an attorney as soon as possible, because an attorney can acquire evidence that might help you to get a favorable outcome when it comes to monetary compensation. Insurance companies are big businesses, and they have their own investigators. And if they know of a claim, they can immediately get to work on minimizing the amount of money that they might have to pay out. If you have an attorney, your attorney can look for evidence that might help establish your claim. You could rest assured the insurance company is not going to be looking for evidence to prove they have to pay more.
All right, that's great advice, Mitchell. Thank you so much for sharing that with us. And I believe it's now time to go ahead and go to our testimonial video, but do you have any last words before we move on?
To consult with an experienced attorney should be free and confidential. And if you contact us about any concerns you have, we'll give you that free consultation, and keep your questions in confidence, and you don't have to worry about us going to your employer or your insurance company without your consent. But the most important thing is, beyond any money we could get you, we hope that you enjoy robust, good health. And that's the most important thing. We wish you health and safety.
Very well said. Again, consultations are always free and confidential. Feel free to call us at any time, 1-800-321-1234. Follow us on all of our socials, Facebook, Instagram, subscribe to us on YouTube so you never miss a beat or our next video. Bye, guys.
I was going straight and a minivan was making a left-hand turn. I was very scared and I actually got referred here by a friend of mine. I had a broken thumb and a sprained knee. Oscar was my attorney. He made everything very easy, asked for all the documents, sent them over to him. Everything was fairly quick in terms of everything. I mean, I've never had an attorney before, but as far as attorneys, I felt he did amazing. Yes, they should definitely go with Bronner.